Welcome back to another episode of SDL. I'm Mitch Hayes.
And I'm Greg Vinogradsky.
And on today's episode, we're going to talk about FDCPA. Specifically, we want to talk about ensuring compliance with the Fair Debt Collection Practices Act, because there's now a lot of collection actions that are going to be started as moratoriums are going to be lifted. So let's start. What is the FDCPA, Greg?
That's right. So the FDCPA is a federal law. It's been around for decades now. And essentially, it's meant to protect consumers from deceptive practices by debt collectors. So there is a lot that goes into this law. We could probably talk about it for several episodes, and we may, but we'll start with the very basics right now. Essentially relies on strict liability. If a debt collector is found to violate the law, that's it. They're in violation and they're susceptible to a lot of potential penalties. And the basic premise of the entire statute is that it's meant to prevent deceptive and deceitful and misrepresentations by debt collectors to consumers. And there's a lot of case law out there as to what exactly is deceptive, deceitful, or what is a misrepresentation. And it's really not as clear cut as you may think, and it may depend on what federal court you sit in.
Yeah, so this is a statutory law. It's based in statute, and since there's a statutory law on the books, there are statutory violations. Now, the key to this law is that every time you violate the FDCPA, you're responsible for $1,000. That's the penalty. But the key for attorneys that are prosecuting these claims, consumer firms, is that attorneys' fees are awarded for the violations. That's the linchpin of these cases. That's where attorneys try to get you as a claimant on as a defendant, is the attorney fee issue. So you want to make sure that you're defending properly and that you're trying to settle these cases at the earliest possible opportunity, or if you can avoid them altogether. So we've talked about the FDCPA. Let's talk about how we can prevent these claims from happening. So there's lots of case law out there. There's lots of statutory law out there. But what do we need to do to give our viewers and potential clients out there some lessons, some tips, and highlighting a few areas of concern that we feel is necessary to help defend these claims?
Yeah. Unfortunately, there is so much case law out there. There is so much kind of uncertainty as to what may or may not be. None of the things that we can tell you will definitely guarantee that, you won't have a complaint filed against you. All you can do is your best to avoid it by following a few steps. So, the first one would be probably to ensure that the language you're using has been approved by the courts. Because there is so many cases out there that have decided what is or is not a Fair Debt Collection Practices Act violation, ensuring that your letter complies to a T, every word, with what has been approved by the court is very important. Now, I'm sure everybody that engages in debt collection services is aware that they have to identify themselves as a debt collector and that their communications can be used for the purposes of debt collection. I mean, that's pretty easy. But there's a lot of more specific things that may not be as clear cut that you want to look to your case law in your area for. Things such as whether your debt is continuing to accrue, or whether it's more of a static debt that is more clear cut as to what is exactly owed. Now, that language is very, very important to use. The other thing that's important is to ensure that your debts have supporting documentation around it, right?
Right. So you want to make sure that if you own the debt, that you are having the proper documentation to support the debt. That if you get in front of a court, if you get in front of a judge, that you have that documentation to back up any debt that you have and that you're trying to collect on.
Right. And that could be, a promissory note. That could be bank statements, just something that is more than, we'll say, like a spreadsheet that you might get, or just an initial communication regarding what the debt is. You need something to support that, and you need to be able to prove that in the event that you do actually get sued, that you have some reliance on what you're doing. And that goes to kind of the next stages here of trying to protect yourself, is to, know your rights and know your debtor's rights. What can you do? Can you actually sue the person if they fail to pay this debt? Can you foreclose on their property? Knowing whether you can or can't goes to the level of a threat that rises to a fair debt collection, because it may be deceitful, may be a representation if in fact you can't sue because the statute of limitations has expired, you can't foreclose because you don't have the proper promissory note in place. Saying that you will may be a violation. It's also important to understand the debtor's point of view and what their rights are as far as validating debts. What does that mean, and what do you have to provide to them to validate and verify that for them so you can continue pursuing that debt? And what's the time frame for when they have to do that? So those are important things to think about, just in general, to hopefully avoid one of these lawsuits.
The last one we want to touch on, again, numerous ones out there, but the last one that we want to touch on that we think is very important that everyone should know is the least sophisticated person standard. It's a standard that's been highlighted by the courts, and that's what you should think of as you are writing your collection letters. As you're sending them out, you want to anticipate how the least sophisticated person that you're sending it out to is going to view the letter. Remember, every violation in that letter could be accruing up for penalties. So $1,000 per violation. So you want to make sure there's no legalese in there, and that it's a very simplistic letter that gets the point across that you're trying to collect a debt, that you are a debt collector, and that the person should be notified that this is an attempt to collect on a debt. So that's the standard that you should be using as you think about sending these letters out.
Thanks for tuning in to another episode of SDL. Check us out on our social media platforms, and we'll see you on the next one.